That's a little bit. I'm over here. I'm over here. Yeah. I apologize to everyone. I have a camera that's on the big monitor where I have you folks, and I have the camera on my actual computer over here. And half the time one works and half the time the other one works. So I will move everyone down my computer. All right, Tracy, can you hear me?
I can hear you.
All righty. So we shall go on the record with proceeding number 24F-0204E. And hopefully I'm not going to mispronounce his name, Howard Kiyota versus United Power Incorporated. I'm Administrative Law Judge Robert Garvey. Today is the 15th of October, 2024, approximately 10:01 a.m. This proceeding comes on for a pre-hearing conference. I'm going to start with appearances. And first off, Mr. Kiyota, did I say that your name correctly? And you got to unmute yourself. Still not unmuted.
Oh boy.
Okay. Try it.
Yeah. Good morning.
Good morning, sir. Am I pronouncing your name correctly first off?
Yes, it's Howard Kiyota.
Kiyota. Okay. Kiyota. Okay.
Yes.
And you're representing yourself here and
Yes.
for United Power. And do you have a camera or not on your?
Yes, I do. I don't know how to get it turned on. I've got the Zoom and I can hear everybody. I can see everybody, but I didn't know how to get my camera. Let me see.
Is your camera on your laptop?
Yes, there we go.
Oh, hello, there you are. Good to see you. Okay.
Good to see you. Thank you.
And for United Power.
Good morning, Your Honor. Matt Larson, Wilkinson Barker Nauer, LLP, on behalf of United Power. I also want to enter the appearance of Sam Eisenberg, also with Wilkinson Barker Nauer, LLP, and Andre Kaiser with United Power.
All right. Good morning. Good to see you again, Mr. Larson.
I know. It's been a long time, Your
Honor. All right. Very good. Well, this comes on for pre-hearing conference, and I did see that the consensus procedural schedule that everyone filed. I do appreciate you can talk, and I will just let you know a few things, Mr. Larson. Mr. Kiyota has reached out to my legal assistants to make sure that I had different things, just procedurally, nothing that he's not emailed me or anything like that. And anything. One of the things that he asked about was, I guess you'd send him an email and he wanted to know whether it was okay to contact you and stuff like that. And we said, yeah, sure, do that. So we always do that. And Mr. Kiyota, what I always do, honestly, when I have people, Mr. Larson, when did you first start appearing before the commission, Mr. Larson?
It's probably been about 12 years, Your Honor.
Yeah, it's about 12 years. About 12 years ago, I started with the commission. I left for a little while. I came back. I've seen Mr. Larson many times. You can talk to him. I always try and tell people that are representing themselves, especially if there's an attorney that I have been around. I mean, he's an attorney. He's going to represent his client. I can't tell you that he's not going to do that. But Mr. Larson's a good guy. He's not going to try and trick you or fool you or do anything like that. He's going to be upfront and try and reach an agreement. So you can talk. I always think if you're representing yourself, you're like, oh, that guy's an attorney. He's gonna play tricks on me or something like that. Again, he's going to represent his client. He's got to do that.
Sure.
But he's not going to try and trick you into doing something that you lose your rights or do something. He's a good guy.
Okay. Thank you.
I promise you that. Like I said, I always feel it's important for me, especially if I've been around the person for a while, to trust him. I've never seen him do anything you need to worry about.
Thank you.
Yeah. So main reason I want to do this, especially when I have a pro se party representing themselves. So I want to make sure, Mr. Kiyota, that you know exactly what you're getting into, what you need to do, and make sure you understand things that are happening. And then if we have a hearing, you're going to know going in what you can do and what you can't.
Okay.
And hopefully you can figure out what you need to do. The first thing I want to ask you, though, before I get too far into this, Has there been any mediation that's been attempted? The commission offers mediation, and when I first saw this case, I thought maybe you might want to consider mediation. It would not be in front of me; it'd be in front of the other judges here at the commission. You can't use anything if they say something, or you say something, or anyone says something in the mediation. It stays in the mediation. You can't call the judge that would be presiding or working for the mediation in the case. So have you considered that? And Mr. Kiyota, I'll ask you first.
Your Honor, when this first started happening, there was a time for a mediation, but I was on a vacation for like a little over 2 weeks. So I just declined the mediation, and I didn't hear anything from United Power.
Okay. Would you be open to it now?
Yeah, I'd be open to it to discuss. Okay. Yeah.
Mr. Larson, what do you think?
Sorry, it was my turn to have a problem getting off mute. Your Honor, I think we could try mediation. I think we have reservations about the ability of this matter to settle, just kind of given everything that's occurred. But if your desire is that we try to mediate this, I think we could give that a shot. In the alternative, we did work on this schedule with Mr. Kiyota. And Mr. Kiyota, if I'm mispronouncing your name, please tell me. We did work on this schedule in the interest of advancing this as quickly as possible.
Well, I think we might be able to do both. I think we can. I can't schedule the mediation because it's not going to be before me, so I don't know what my schedule is. But one of the things that you have proposed in the schedule is pre-filed testimony, and I know, Mr. Larson, that in most of our nice big giant raid cases and stuff like that, Mr. Kiyota, we use pre-filed testimony, which. And I don't know if Mr. Larson went into you what that means or anything like that, but any witness you have is you're right. And I know you have some experience with, I guess you worked at with public service, but I don't know if you have any experience with that and pre-filed testimony.
I retired from Excel. I had 30 years with Excel Energy.
Did you ever do anything in the hearings or anything like that?
I filed a bunch of things for PUC approval, but I really didn't have to go to the PUC to do any testimony. Okay.
Yeah, but pre-filed. My main question is just pre-filed testimony. I can get lawyers in here, and I said pre-filed testimony, and they look at me like I'm speaking a foreign language. So,
no.
It's one of the odd things that we do here that's not done. It's done in some administrative proceedings, but what we're talking about there. How many witnesses do you think you're going to have, Mr. Kiyota?
I'll probably just do this solo running by myself. I have emails, texts, that kind of thing. If I have that from a person, do I need to have them testify?
I can't tell you how to do that. I mean, it kind of depends if you think you can. I can't tell you how to be a lawyer. That's one thing I can't tell you.
Okay.
It's whether you can get it in. And I'm going to get it a little bit into the stuff. But now you can testify. Here's the one thing is in this case you can testify. If you testify, you don't have to do. You don't have to run back and forth between. You ask yourself a question and then you answer the question. You can just kind of talk, and that's a common thing. And if you're that's the one thing that I was wondering, if you have more than witnesses than yourself, I don't know that we actually need or want pre-filed testimony. It would probably be easier to not do it.
Okay.
Mr. Larson, what do you think about that? I mean, I guess Mr. Kiyota, is there, like I said, are there any other witnesses that you think you would have or you'd need?
I really don't. I really don't.
Okay. What do you think, Mr. Larson?
I think one of the things that, one of the reasons, and I recognize that, that's how we traditionally, structure schedules in larger cases. I think one of the reasons we went with the pre-filed testimony approach here is just because of the fact-intensive nature of the inquiry here. We have a lot of facts we want to get out. We wanted Mr. Kiyota to have the opportunity to write up kind of his side. My understanding, and I don't want to speak for you, Mr. Kiyota, from speaking to him and structuring this schedule, was he wanted an opportunity to respond to our answer. That was one of the reasons we went down this route. If we want to go down a different pathway, I think what we would ask is that we do get a chance, working backwards from like a January hearing, if that's something that works, to be able to put something in writing whether that's a report or a testimony or something along those lines, just so we're able to kind of lay out in a pre-filed manner, everything that has transpired from our perspective with respect to the nature of this dispute.
Okay.
Your Honor, I had a question for you, please.
Absolutely. Mr. Kiyota, I apologize because I should have already said, if anything that Mr. Larson says or I say sounds crazy, please interrupt and say, I got a question. So,
Okay, thank you.
I don't want you sitting there wondering and thinking, and seriously, I used to do this for other cases with folks representing themselves. And I'd say some sort of phrase like discovery. And I'd say, what discovery is? And this is the same with you. If you tell me what discovery is, you're gonna have to define it for me. So I'm not gonna believe that you don't understand anything.
Okay.
So go ahead with your question. I'm sorry.
So I worked with Matt. We looked at a schedule. I was good with the schedule. I just want to understand when the testimony that I give, I'm going to tell my story. There's, United Power filed that answer thing on the 8th. Do I address that letter in my testimony, or is that something I have to do separately?
Well, here again, I can't give you legal advice on stuff. You don't really need to worry about that answer for right now. Okay. Unless you see things you don't necessarily. So what's going to happen? And I guess we'll start this way. This is the best way I'll do this. So again, and if I say anything that doesn't make any sense here, please stop me.
Okay.
We'll go through it. So what will probably happen here, or what we're scheduling here, is going to be a hearing, and the hearing is going to take place kind of like this. We'll figure out whether we're going to have pre-filed testimony or not pre-filed testimony. And honestly, one of the things you might want to do, all of our stuff is online, and you can watch a hearing, you can see what happens on it, get a feel of what happens away. If we have so you have the burden in the case, that I can tell you. Okay.
All right.
Yeah, you have to prove whatever you got to prove. You got to prove how you got to figure out how you're going to do it. Okay.
Yes.
That's up to you. And but when you do that, you can use evidence. You're gonna have, and when you have evidence, if you have documentation that you want to get in, we're gonna have that we will definitely have pre-filed, Mr. Larson, for sure. Any documentation. But if you pre-file that documentation, that does not mean it's in the hearing. It's not necessarily admissible. So what you'd have to do during the hearing is try and get that admitted into the hearing as evidence, in addition to any testimony that you'd have, whether it be given live or be given through a written form. I will tell you, and the same thing goes for United Power, they'd have the same things. If documents you're trying to get in, you have to lay a foundation for it. You have to ask for admission. The other side can object to it. You can object to anything from United Power. I will tell you, I'm not going to hold you responsible for being a lawyer or knowing lawyer words. Okay. Sure. So one of the things the example I always like to use, if Mr. Larson decides that his high school graduation picture is incredibly important to get into this case, and he says, Your Honor, I'd move to admit Exhibit 1, which is my high school graduation picture. And you go, Your Honor, I'm going to object to that. That doesn't have anything to do with that here. What does that have to do with my electrical system? Yeah. I'm going to go, Mr. Kiyota, I agree with you. I'm going to find that that's not relevant, and I'm not going to admit that piece of evidence. So I'm not going to hold you to know that word relevant, but right. You can't just say, hey, you know what? That really hurts my case. I object to that because that stinks. It's going to make it hard for me to win. Not a legal argument. Okay. Okay. So you're going to present your case. You're going to do it through testimony, like I say, either orally or through written form. Get your exhibits in. When you're done with that, Mr. Larson will have the opportunity to cross-examine you and ask any questions of you that he may have based upon that. When he's done doing that, I'll ask any questions I have of you, which is kind of the way I want to. If you're not, I kind of want to hear you talk a little bit so I can inform questions too. When we're done with that, then you'll have the opportunity to do a redirect of yourself, where you can kind of, if Mr. Larson poked holes and stuff and you want to kind of try and repair those holes, you can. Or if I poked holes and stuff, you said, you can do it that way. Okay. You'll do all your witnesses that way until you've felt you've won your case, or you've presented all your evidence and tried to. It'll be then Mr. Larson's turn. Mr. Larson will then call his witnesses, try and make his case. You'll have the same opportunity to cross-examine his witnesses. Even if they have written testimony, I'll tell you, just if you never were in one of our cases, even if there's written testimony, they will be there.
Okay.
So the way it would happen is if Mr. Kaiser is one of the witnesses and Mr. Larson has pre-filed the testimony, he will call Mr. Kaiser and he'll ask Mr. Kaiser about 3 questions. He'll say, did you file testimony for this? And he'll say, yep. And he go, you got any changes for that testimony? Nope. Is that exhibit 103? Yep. Okay, we move for exhibit 103 to be admitted. And now we turn him over to cross-examination. So you'll have read that testimony and then you could ask questions of Mr. Kaiser. Again, when you're done asking those questions, and I would ask questions that I have, and then Mr. Larson will have the opportunity to redirect and try and fix any holes like that might have come up. He'll go through all his witnesses, we'll do that, repeat that many times as necessary. When that's all done, then you'll have the opportunity, if you want to present any rebuttal case. And rebuttal case has to be based upon things that were brought up during their case. So it can't be a new case. You can't bring up new things or anything like that, but just to respond to what they brought in their case.
Okay.
When that's all done, I will tell you that I will not decide the case when we're all done. I'll take it under advisement. That's the way we do things. We have to issue out everything in a written decision. I may or may not ask for a written statement. If I think there's some questions out there, I'll ask the parties. If you guys want to write something and file it later. Bigger cases, I normally do that. There's more things like that. These cases are a little bit smaller. It's kind of a generalized issue. I generally don't need it, but I might. You never know. And then maybe about 30, 45 days after that, I'll issue out a decision.
Okay.
All right.
Your Honor, just how I need to provide my testimony, my exhibits, my videos, all of that. How soon do I need to submit that in, and who do I submit that to Matt and to you? Well,
you'd file it with you. I mean, if you file, you've used the filing system that we have with the
e-filing. Okay.
Yeah, the e-filings, and that gets to Mr. Larson and gets to me and gets as long as you got that, you're good to go as far as getting it to the other side.
So how soon before I testify do I need to submit the documents?
Well, that's what we're going to figure out. That's part of what we're doing here today.
Okay.
So I don't know. That's part of it depends on whether we're going to do written pre-filed testimony or not. I guess say, Mr. Kiyota, I just don't know if you're the only one. And I don't know, Mr. Larson, I don't think I've ever done it this way before. I'm doing all sorts of things new since I've come back. I don't know if Mr. Kiyota does not want to do written testimony, and you do. I mean, I could allow that for the ease of your, if there's things that you want to present that way. I mean, what would you feel about that? How would you feel about that?
Yeah, I mean, our top priority, number one preference, is to have the opportunity to do our written testimony and explain kind of what's happened. And I think the rationale behind going with a more traditional direct answer rebuttal was just to try to make the hearing as efficient as possible once we got to hearing, because it is a fact-intensive inquiry here. In the alternative, if Mr. Kiyota does not want to do testimony, we tried mocking up a alternative schedule, where we would essentially keep the hearing date as it is, keep the exhibit list, cross matrix date as it is, but we would do answer testimony or a report of some type on December 6th, and discovery be ongoing throughout that period as we try to develop that. So that, to your question, that would be an alternative way of doing this if Mr. Kiyota does not want to do testimony himself.
No, I look forward to doing testimony.
No. He means pre-filed written.
Okay.
Yeah. Okay. That's it. Yeah. No, you're going to do trust me. You're going to do testimony one way or the other. That's going to happen. Part of it is I don't. You're not. I mean, just because you're not used to it, and I think it would be kind of weird asking yourself questions on it. And part of it, I got to tell you, I kind of want. I think it's a lot for someone who's not an attorney to do on their own, and especially if there's only one witness. It's not. I'm assuming, Mr. Kiyota, you're not going to be testifying for 2 days.
No.
I mean, I assume you're testifying, especially if you're just telling me what happened. It's not going to be incredibly long.
No.
So would you mind? That's my gut. Most of these cases, I don't. It's pro se. I don't have them pre-file testimony. I haven't done that. So, Mr. Larson, I'll ask you, what's your preference? Would you want to just do answer testimony, or would you want to just do a report that can be, and the report could be just, I mean, what I do is I do this like a transportation case where there'll be a date to file any kind of documentary evidence that you have. We'd have that exchange still happen, but the testimony itself would not be. That's the way we normally do the transportation cases. So any exhibits would be pre-filed, and then we do the testimony live if you want to do it that way. Mr. Larson, what do you think?
Yeah, I mean, I think doing a report would be okay from our perspective. You know, on that, you know, like I said, December 6th was kind of the date we looked at for doing that.
Okay.
You know, allow us to, you know, get our materials together, and then we could proceed to hearing. I anticipate we'll probably have between 1 and 3 witnesses at the hearing. I don't know quite how many yet.
Okay. But you don't want to do you don't want to pre-file their testimony? You can if you want.
We're agnostic either way. Whatever's honestly better for you, Your Honor. Preference between a report and the testimony.
Your Honor, what exactly is the pre-trial testimony then?
Okay. So, and what it is what they would do is, let's say Mr. Kaiser's their witness, and so there might be 30 pages of question and answers to Mr. Kaiser, just, you know, what he does. And instead of Mr. Kaiser getting on the stand and Mr. Larson doing a direct testimony of Mr. Kaiser explaining who he is, and then explaining whatever evidence he wants to testify about your case, it would all be in a written form. And so we basically, what it does is, instead of doing the direct testimony, that's the direct testimony.
Okay.
Of doing that. And so you'd have that in a written form, and we'd just start, like I say, we would just start with the cross-examination.
Okay.
And I'll ask you, Mr. Kiyota, would you rather hear him do the direct testimony live, or would you rather hear it, or would you rather have it in a written form that you can look at before the hearing?
Probably written form that I could look at before the hearing would probably.
Okay. I mean, sometimes that's good, and sometimes it's bad. It makes it easier and quicker in the hearing itself. I mean, that's why when you have a rate case, you know, we've got all these experts and we got so much stuff there, and we got to look at it all. And the guy testifies to something about we can't figure out real quickly to ask questions.
Right.
So you have it pre-filed, and you can then do it that way. So okay, Mr. Larson, what do you think? How about you file a report and do answer testimony? Unless Mr. Kiyota, I'm going to let him testify live. How's that?
Yeah, we can go the report route, Your Honor, and then put witnesses on at hearing.
Okay. You want to do live? You want to do live? That's fine. That's fine. I'm not gonna force you to do written testimony if I don't force Mr. Kiyota to do it.
Yeah.
So I got to be fair, Mr. Kiyota.
Sure.
Okay. Yeah. All right. I'll have you report the 6th. I got to talk to you about that date for the hearing, though, because that week is a real bad time for me. I have 2 hearings that I have some of that gosh darn written testimony in.
Your Honor, you're talking about the week of the 20th?
Yeah, I'm in a hearing the 16th and 17th, and then the 20th is MLK Day, and then I start another hearing on the 22nd or the 24th. So that's a little crowded for me. So if you can go to the next week, you can go to the week of the 27th. That would be preferable for me.
That works for me.
Your Honor, I closed my Outlook down for this hearing, so I'm calling it back up to look. And I would also look to Mr. Huffick and Mr. Kaiser to see if there's any issues from United Power's end with the week of the 27th.
Matt, you just need to be retired like me, then you don't have anything in your Outlook.
Looking forward to that, sir.
I got to make me retired too while you're at it, would you?
Yeah.
Come on, I'm good to be retired.
I've only been retired this is my 11th year.
Oh. You want to win your case, don't you? Don't tell me stuff like that.
I don't see any conflicts on my calendar. Andre, I don't know if you have any conflicts on yours since I can't see it.
27th also works for me, Your Honor.
Okay, well, I mean, I can say, how about just that week? Yeah, let
Mhm.
me see.
Your Honor, 27, 28 would be best from my end. I could be flexible if needed, but either that Monday or Tuesday would be.
Let's do the 28th. I hate starting a hearing on a Monday. I hate ruining everybody's Sunday night.
I know
If
all
there's-
about this, Your Honor. I agree.
If there's one thing you should know about me, Mr. Larson, by now, the amount of days that I have hearings on Fridays and Mondays is limited. Not a big
Yeah.
fan of either of those days. I'll start it before Friday, but by God, at 5 o'clock on Thursday, we're moving a lot quicker. Okay, report on the 6th. I'm going to send you guys some information on mediation. Okay.
And that's the 6th of December, Your Honor.
For your report, yeah, we'll stick with that. I'm not going to worry about. What I'll say is that all your exhibits, Mr. Kiyota, so what we're going to do, any exhibits that you want, I'm going to send out and don't worry about this. There's going to be a decision I'm going to send out. It's going to have instructions on how to get your exhibits together. You're going to pre-number, pre-file, pre-number them, pre-mark them.
Okay.
With a numbering system, so we have that. You have had contact with my legal assistants who are very wonderful, and they're much smarter and much better at these things than I am, and so they'll make sure that we get this all together. But
Okay.
that'll have instructions on it, and so we'll keep that date of the 8th for you to file all of your exhibits. And Mr. Larson, you can file your report and your exhibits on the 6th. Is that all right?
So just so I'm clear, we would have our report on December 6th, and then the exhibit list would be January 8th or January 10th.
No. Well, I tell you what, if you want to make it, I was using your schedule that you had before. If you, because we can you do your exhibits on the 6th? Do you want to do your exhibits on the 6th with the report or not? Or do you need more time with that?
It may be helpful to have a little bit more time just in the event that there's additional exhibits that go beyond the report.
Okay, let's give Mr. Kiyota a little more time then too. So, Mr. Kiyota, you can have until, let's see, Thanksgiving's on. How about until I'll give you another week, till the 15th.
Now this is to give my direct testimony?
No, for any exhibits that you want to file in the case.
Okay.
So any paper exhibits, anything like that,
Yes.
pre-file all those and number them. And like I say, there'll be a decision that tells you exactly how you need to do that. And if you have any questions, again, shoot it to to one of my legal assistants, and they can.
So, Your Honor, I'll prepare my testimony. I've got a bunch of exhibits, a bunch of videos, all of that stuff. So as long as I file that in the e-filing system before November 8th, that'll be okay?
I'm going to give you till the 15th, but yeah, but you don't have to worry about written testimony.
Okay.
Just any exhibits that you have, any pieces of paper, any.
Okay.
If it's emails, if it's whatever it is, I don't know what it would be. Okay. And then report on the 6th, Mr. Larson, and how about the 20th for any exhibits that you have?
Yeah, I think that will work from our end.
Okay.
So, Your Honor, is my direct testimony's date is also changing then, right?
You're not going to worry about direct testimony. You're going to present your direct testimony live. Okay.
Okay. But it's still on November the 8th?
That's just the only thing you have. No, don't worry about November the 8th. Just
It's gone.
Doesn't exist anymore.
Okay.
And I'm going to send out a schedule that has this on it, but it's the 15th.
Okay.
And all you have to worry about then is, and I know you've done this with some of the things you've done. You filed a bunch of exhibits and different documents to
Yes.
bolster your case. So that stuff is what you're going to have to refile, that number and stuff like that. But not any written. And so when we have the hearing, you're gonna get up and you're gonna tell me your story, basically.
Okay. But I do not have to physically send this to United Power, or do you,
No.
just as long as I
No.
do it through the e-filing?
Yeah, you're good
Awesome.
then.
Okay.
As long as
thank
it gets some defiling, they'll get it.
you. Okay. Thank you.
And then I'm not settlement date. You don't worry about that. I don't care about a settlement. You can settle the day of the hearing. I don't care. But I'm not gonna tell you no if you get a settlement after that. Let me see. Oh, that's a good point. And Mr. Kiyota, that's why that's why I say my legal assistants know more than I do, and they don't screw things up. Because Casey just sent me a thing saying that you can't e-file the videos, so those you will have to physically
Yes.
get to
Yeah.
them and stuff like that. So
Okay. Yeah, I've done that.
okay, but yeah, so then we'll have the hearing on the 28th. Are you available the 20th? Is everyone available the 29th? Is there anyone not available the 29th? I don't think it would go that long.
Yeah, if it runs over, I can make myself available the 29th, Your Honor.
Okay. I don't have anything now, and I don't have anything now, and I wouldn't plan to put anything, but just keep it in mind that if we go over, that might happen. And then, like I say, I'll determine at the end of the hearing whether we need statements of positions. Let's see that. Okay. All right. Mr. Kiyota, what do you think?
I think it's awesome. First of all, I want to thank you for, taking my case, and I'm excited to do this.
It's, actually, I would say your tax dollars pay for that, but it doesn't, because actually the utilities actually pay for it. So thank United Power, because they pay me actually, kind of, because that's what pays for the commission itself. But that's my job. It's my job,
Yeah.
Mr. Kiyota. That's what I got to do.
So, Your Honor, I just want to make it clear you're going to reschedule my direct testimony to November the 15th.
Stop saying direct testimony, because you're getting me worried when you say that. Okay, just your exhibits. You're going to file your exhibits.
Just exhibits. Okay.
Right. That's all you're going to be. All right. I'll try and make it clear in the decision that I write out. And if anything's not clear, all you got to do is file your exhibits that day.
Okay. I'll file it before that date, just to make sure.
I don't care. I don't care as long as you get it there by that date.
Yeah. Okay.
And I will tell you, if you can't do it by that date, right now my wife is pretending that I was in a car accident because she has a job interview. Okay. So if something like that were to happen to you, all right, you have to get in a fake car accident like I am today, and you can't do it. I'd call Mr. Larson, tell him I need more time or whatever, and just file a motion and do that. Okay.
Okay.
But you got to do that ahead of time. I guarantee you, I'll probably grant it. I'm sure Mr. Larson's not going to care too much. If he does, he knows I'll get mad. But you can do that too. So, as long as
Your Honor, when it's time to do the testimony, this is going to be live down at the PUC.
We'll probably do it like this.
Okay.
We'll make it easier. I think it's easier to do it this way. It's easier for people not to have to get down there and stuff like that. We'll do it remotely like this. And just for information, you have this stuff all pre-filed. There'll be instructions that you get in the decision that my legal assistants will make it so that they pull up all the exhibits that you have when you call them. So you'll say, could you pull up exhibit 101? And Casey will put that up there, and you can say what you want. Say, look on exhibit 101, blah, 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 and tell me whatever you want me to see.
Okay.
So that's the way we handle these. I find it easier to do it this way. It's much easier for witnesses. They can go and do what they want. It's easier for me.
Yeah. Okay.
So you can ask Mr. Larson. Mr. Larson was involved in the first hearing that was done in the commission this way, which was a big giant one that he won. That he won in front of him.
As was Mr. Hubbock, I believe. We all learned on video together.
Yeah. No.
Yeah, that was an interesting experience. If you don't mind, Your Honor, is it possible to just run back through the dates from my standpoint, make sure we got them right?
Absolutely.
So I've got November 15 for Mr. Kiyota's exhibit filing. I have December 6 for the United Power report. I have December 20 for United Power exhibits. I have January 28th for the hearing. One day, understands possible, goes to 2. And then with respect to statements of position, that'll just be determined by Your Honor at the hearing, depending upon how things go.
Right. And I'll send you, the only thing I would add to that is I'm going to send you information or have information sent to you about mediation, which I'm not going to force you to do it, but you might want to consider it before the hearing. If you think there's a chance of getting something figured out there. That's just something to consider.
Yes,
So,
thank you.
but yeah, and again, Mr. Kiyota, I cannot stress enough. If anything comes up, if there's any questions you have for me, include Mr. Larson on the email.
Okay.
Okay. I can't, like I said, I can't tell you what you need to do. I can't tell you stuff like that.
Right.
Procedurally, I can answer procedural questions, stuff
Right.
like that.
Yeah.
But I get, Mr. Larson's not going to email me unless he puts you on it. So
Okay.
Mr. Kiyota, to the extent there's going to be correspondence with Judge Garvey, you and I can just coordinate on that. I will reach out to you if we need to do that, and just please reach out to me, and we'll be reasonable about it.
Sure. Yeah.
Oh, and one of the things I better go over here. Also, you can talk to Mr. Larson. Do not include me on that.
Yes.
That's one thing. That's one thing to make sure you do. I do not care what you two talk about. Okay, you guys can talk about whatever you want to talk about. I want to know about it. Okay.
You mean if I tell Matt where to go to catch a 12-pound rainbow, I don't have to tell you?
Yeah, it's exactly. You don't need to tell me that. And
I'd appreciate it if you would do that.
I don't want to know any of that stuff. Okay, we can do that. You don't understand what discovery. I mean, you might get the discovery propounded on you. You know what we mean by discovery?
Where Matt has looked up and has evidence that he wants to present at the hearing, right?
Well, he might ask you questions. He might have things that cause over different interrogatories, they're called sometimes, or admissions, or I'm not sure what they might do, or ask for documents, stuff like that you might have. And you can ask that same of United Power too.
Right.
And
right.
So if you suddenly get an email and he asks you, do you admit or deny? I don't know I don't know if he's going to do anything like this or not, but or how many times has this happened, or how many things have blown up in your house? He can do that.
Okay. Sure. Yeah.
And so if there's any question, again, if he asks you something about, I don't know, something that has nothing to do with this case, how much money did you pay for your car? Yeah, and you say, I don't think I need to answer that one. Yeah, you can come to me and say, I don't think I need to answer it. Something like that. So he can't just ask you anything. It's got to be related to the case.
Right. No, I've talked to Mr. Larson. It's been very cordial, professional. So I have no problems with that.
Good. No, he's a good guy. He's a good guy. He won his case in front of me. He won a big case. You won $1 billion case in front of him, Mr. Kiyota. So think about that.
Nice.
And if we do propound discovery, I anticipate we may have some questions. Is it a 10 business day turnaround, Your Honor?
Yeah.
And Mr. Kiyota, we'll include the due date for the responses in any emails that we send to you.
Okay.
And if you need extra time to respond to them, I just ask that you reach out to me, and so we can coordinate on when you're going to provide the information.
Yeah, I'm willing to cooperate, whatever you need.
Yeah, likewise.
Yeah. And I'll say, this is my one thing I always say, that's why I said mediation. If you can work this out and figure out an agreement that makes everybody happy, that's the best thing. And I certainly encourage that every time. So, and certainly if the commission can help in any way through mediation or any other means, please reach out. We'll do what we can.
So, Your Honor, you're going to send some information on the mediation that I could look at before I take the map.
Yeah.
Okay.
Yeah. I'll have your name's April Woods, this person's in charge of mediation, and like I say, it would be in front of a different one of our other judges, who I can't say are nearly as good as I am, but they're certainly okay. All right. So, but we'll get you all figured out. Mr. Kiyota, last chance. Any questions? Anything doesn't make sense? Again, even if it doesn't, like I said, I'll issue out a decision, which hopefully will answer some of the questions you might have. And you can reach out to, like I said, one of my legal assistants, and hopefully they can figure it out if something in my decision doesn't make sense.
Awesome. Thank you, Your Honor. Thank you. Appreciate your time.
No problem. That's my job. It's my job. What I do. Mr. Larson, you got anything?
Nothing further from United Power, Your Honor.
All right then. All right. Thank you everyone for being here. And if nothing else, we'll be in adjournment. Thank you
Okay,
very much.
thank you.
Bye.
Thank you.